Be mindful of sections 426 of FSMA. Dealing with them in reverse order, section 26 of FSMA says that any agreement entered into in breach of the general prohibition is void and unenforceable. And so if you've lent monies out under that agreement or taken security out, you're not going to get it back. Also, the counterparty, the innocent counterparty to that agreement, which could be the consumer or could be another business, has the right to reclaim any money or property paid over or transferred under that agreement, and also has the right to obtain compensation. Turning now to the definition of claims management services. It's defined under FSMA, that's section 419A, and it's defined as advice or other services in relation to the making of a claim. There are two separate definitions within that definition. First, what is other services? Well, it includes financial services or assistance, legal representation, the referring or introducing of one person to another, and making inquiries. Don't worry, I know this sounds quite confusing. On the next slide, there's actually quite a helpful table that you can find from one of the FCA, on the FCA website, and in one of their policy statements that sets out quite an easy and digestible format the specified activities in relation to each in-scope claim and the permissions that are needed for those, and we'll turn to that in a second. Before we do, just remember that agreeing to carry on a regulated activity is itself a specified activity for which permission from the FCA is required.